Thank you for watching. My name is Muhammad Abduroaf, and today's topic is child custody and child guardianship rights. What are the differences? How does it work? Firstly, many people approach me and they tell me, Advocate, I would like to have custody over my child. Or they tell me, Advocate, I would like to have guardianship over my child. But when the conversation continues, it's clear to me that they do not understand the difference between custody and guardianship. Custody, another term sometimes used, is the term care. That's more the legal definition, the term used in the Children's Act. But guardianship remains guardianship. Or a party will come to me and say, Advocate, I want to have sole custody over my child, but they might be referring to guardianship. What is the difference? Firstly, guardianship. Guardianship is a legal definition. It's a legal concept in the sense of it deals with the legal aspects of a child's life. If a child wants to apply for a passport, he or she requires the guardian's consent. Or if a child wants to purchase a home or contract or deal with something that the law requires consent from the other parent, that is where that parent has to give guardianship consent. To make the example a bit more easier, guardianship has nothing to do with your rights to see your child. It is possible for a parent to have guardianship rights, but no rights of visitation or to have any contact with a child. So guardianship only deals with the aspect of legal, giving the child consent or providing consent for legal aspects of a child's life. For example, if a child wants to apply for a passport, both guardians have to consent for that. And at the same time, if a child needs to leave the Republic of South Africa, both guardians have to consent where that is concerned. Now, custody or care, that deals with the aspect of physical relationship between a child and a parent. If you have custody of a child, it means that the child is living with you. You're caring for the child. It's a physical aspect. The child lives in the same home as you. Care, the same thing. If you have sole custody over the child, that means you're the only parent that can care for the child. The other parent cannot care for the child at all. The other parent might, for argument's sake, have rights of contact and visitation with the child, maybe telephonically and so on. But you have the custody rights over the child. So generally, both parents will have to be co-holders of care or custody over the minor child, and they will ultimately have to decide, or the court will assist them, in how the custody and care rights will be exercised. For argument's sake, the child might live during the week with the mother. The mother will make sure that the child's homework is done, schoolwork is done, care for the child, take the child to the doctor, extramural activities. So the mother is the one that has primary care or primary custody. It's all legal terms or not so legal terms, but that's basically how we sometimes describe it. Where the one parent who has custody over the child or care over the child will provide certain caring responsibilities to the child. But the other parent will have custody over the minor child on weekends, every second weekend, after school holidays, and so on, dealing with aspects concerning care or custody over the minor child. Now, in that specific scenario where the parties are now sharing care and contact or custody over the minor child, now one parent might approach me and tell me, or ask me, Advocate, I would like to have sole custody over the minor child. Now, that is possible, but you have to have very good reason for that. Why you do not want the other parent at all to care for the child, to live in the same home like the child, and to rear the child, for lack of a better term. It's possible if it is in the minor child's best interest, but it's really difficult to find scenarios where the court will do a 360 whereby a parent has custody over the child and now all of a sudden give it to one parent. And then I have the other scenario where a parent never ever has, or never recently for the last few years, had any contact with the child. The child never lived with that parent. The parent never cared for the child. And now the mother, for example, in this example, will ask me, advocate, I would like to have sole custody over my child. They not say, but you already have sole custody because other parent is not involved in the child's life at all. So you are the one that is exercising sole custody, sole care over the minor child. And it doesn't make sense for me to go to the court for the court just to confirm that you have sole custody over the child. You're already exercising sole custody. But it is possible for a court to confirm it in a court order that you have full rights of care over the minor child and the other parent has no rights of care. That is possible. Moving over to guardianship again, as I mentioned earlier on, guardianship has nothing to do with the physical contact with the child. It's a legal responsibility which a parent has to assist a child with certain legal things. For example, if a child wants to get married under the age of 18, apply for a passport, leave the Republic of South Africa, maybe going for an operation whereby the hospital requires both body guardians' consent. And you all know if a child wants to go to an excursion at school, then the teacher sends some form and the parents will have to sign it, or the guardians will have to sign it, or one guardian at least as guardian. Nothing to do with the contact of the child. Now, this is where it becomes maybe more pragmatical in my field of practice. Is a parent will come to me and say, advocate, I'm having problems with applying for the minor child for school because the other parent is refusing or is being difficult. Or I'm having problems with a minor child traveling overseas or applying for a passport. Then they say, advocate, that's why I want sole custody. Long term. The term would be I would require sole guardianship over my child because those are guardianship aspects. That is possible if the court can be convinced that the other parent is becoming difficult whenever the one parent wants to do something where guardian's consent is required. For example, enrolling the child into a school, but the other parent is always difficult, not available to sign consent documents or admission documents, enrollment documents, and so on. The court will say, under these circumstances, I will maintain the other parent's right of care, contact every second weekend, half school holidays, but I will terminate or suspend that parent's guardianship rights over the minor child. So if the mother wants to apply for a new school, only her consent is required. Apply for a passport, only her consent is required. But each case is different. It's very seldom that a court will grant a blanket sole guardianship rights. It might only apply to certain situations, for example, maybe traveling, because there aren't any issues regarding the schooling. The other parent cooperates. Or, for example, it might be regarding medical, whereby whenever the minor child has to do an operation because the minor child is not so well, the other parent is difficult, challenges the parent that wants to take the child to the doctor. Maybe there might be good reasons for the challenge, but the court will ultimately make a decision as to whether or not those reasons are reasonable and whether or not the court should grant the one parent sole rights of guardianship over the minor child. So there we go. If you consult with me or with an attorney or an advocate in the future, and you want to deal with those issues concerning care or custody or guardianship, you understand the different concepts and how it works. Thank you very much.